All right, welcome back to another special report from the unknown. My name is Michael Volpe. I write at michaelvolpe.substack.com. Normally, I live in Chicago, Illinois, but today I'm in Aventura, Florida. That's in Miami-Dade County. And my broadcast partner, he normally is in Florida, and that's where he is today. I think you actually live in Naples, Florida, I found out recently. I'm not even going to say near Fort Myers, but I think that's also in Lee County,
No,
Florida.
no, Naples is actually in Collier County.
So why
Naples,
do you why do you constantly say you're in Lee County?
I'm close to Collier and Lee County. People have to know that I'm in Southwest Florida. So I could be in Lee, I could be in Collier, but
Ah,
my residential legal address is in Collier County in Naples, Florida. And
mhm.
when I tape, I sometimes tape at other locations in
All right.
Southwest
He
Florida.
he he's very mysterious, but we have a very serious subject to talk about. We have talked about Paul Boyne quite a lot. He is back in the slammer. I blame you. You're going to tell everyone why it's not your fault, and I'm going to tell everyone why it is. It starts with this. This is the expansive, unabridged witness list filed by the prosecution. For those who haven't followed, Paul made a series of mean blog posts about some judges, like this guy, Gerald Edelman, and this lady, Jane Grossman, and they didn't like it. Their feelings were hurt. And along with their good friend, the former judge, Joed Katz, pressured the prosecutors and they filed bogus charges. It's a little more complex than that, but it really is not. So he was arrested in the summer of 2023, June or July. It is now February of 2026, and we may get to a trial pretty soon. But Paul has been out of jail for over a year, but right now he's back in jail. Why is he back in jail, and how come it's not your fault when everyone knows it is?
Well, the issue that we have with Paul is there's something that they haven't discovered yet in the state of Connecticut, and that's called the First Amendment, and maybe the entire Bill of Rights. And part of that First Amendment is a free press clause and free speech and a lot of other things. But as germane here, this witness list was sitting on a table in the courthouse. The state
Mhm,
attorney's office had placed it on defense table prior to a hearing, left it unattended for no for anybody to go and take.
mhm,
And Paul, being a journalist, a blogger, whatever you want to call him, took pictures of the list. He scanned it and he sent
mhm.
it to the Virginia State Police. He sent it to Ed Mahoney at the Hartford Courant. He sent it to other independent journalists, yourself and myself, and he sent it all around the world because in his mind it was a public document, a witness list, which had been read
Wait,
to the jury at least three times.
but
In the
is it a public document? Can someone
My
go
answer
to
is
New
the Supreme
Well,
Court
can someone go to the
is.
New Haven court where this trial is held and go to the clerk's office and get this witness list?
If you would have sat in the courtroom, you would have heard the entire witness list
Well,
probably
that's
three
not the same
times.
thing. So you can't get it at the clerk's office. Why do you keep saying it's a public document?
It's a public document because there's no right to seal it. There's no right to keep it sealed and not be used for public consumption
Hmm.
because it's a true document that was produced by the state. The state
Hmm.
produced this document. It's their document. They can't deny its existence. They don't deny its existence as an authenticated state document. Therefore,
Hmm.
press has it. The press can't be stopped from having it, except for in a very, 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 egregious circumstances, and that we have to be like a national security interest or something like that.
All right, but see, all of these people may testify against Paul, and now some people are saying mean things about them, and some of those people are talking to me, and Paul needs to be held accountable. So I can see why they put him in jail. Am I wrong?
I think a little bit. There's
All
only two
right,
people that are complaining, and they're both named Joe Ed Katz.
all right.
That's and,
All
and
right. Well,
actually, Jack.
before we get to my visual aids, that's Joette. She kind of looks like that. Anyway. Let's watch this video that you made because it's so wonderful and it's only 10 seconds.
I've got you now, scumbag. Speak to cats only.
All right.
I've got
So you did a wonderful video. Uh, so basically, what I think triggered it I that is the revoke. His bail wasn't revoked, folks, but in essence, it
Now,
was.
the
Uh,
bond amount was $7,000,
so
and they
I
raised it.
sent because I have Miss Katz's email after I found out she was on the witness list. I said, "Will we finally find out what?" And I should have put quotation marks. Quote, "Speak to Katz only," unquote, means looking forward to your testimony. Speak to Katz only, for those who don't follow, was marked in handwritten hand in pen, I would say, I on a on an email stream written, we believe, by Samantha McCord, who was one of the chief detectives from the Connecticut State Police. She's since retired on this case. And so no one is sure what it means, but we do believe that the Katz is Joette Katz, former Supreme. Was she on the Connecticut Supreme Court, or was she the head of the Supreme?
Justice of the Connecticut Supreme Court, and then the governor, Malloy, asked her to become the DCF commissioner. So she stepped off the Supreme Court at the request of the governor to take over DCF.
And now she's in private practice. And Paul believes she's secretly and off the books, if you will, running this investigation and pulling the strings, as you suggested in that video. And so, foolishly, I included you on the email. I did not expect you to act so inappropriately, but you did. Mike, when is enough enough? Take it easy on Joette Katz. And then you shamelessly plugged one of your articles. She's the modern day Aldo the Apache, and you have Brad Pitt in one of his roles. Plugging your article again.
Michael, that's Inglorious Bastards. Aldo the Apache is the great American Nazi hunter in Germany. And we's in the business of killing Nazis, and a business is a movement.
That's all right, here, let's look. Yeah, one of Brad Pitt's greatest roles from the Quentin Tarantino movie. And Sammy McCord, who we talked about. The reason I believe she has a crush on me is there are some documents where she keeps talking about me over and over and over again. What am I supposed to think? Anyway, you keep plugging more of your articles. I'm more excited to see how all the evidence problems will get resolved. You plug another article. Hey, Sammy, was the other Connecticut, quote, law enforcement tourist present at the Boyne, Virginia raid, Janina Bonilla, Connecticut State Police witness list? If not, who was it? Favor of reply requested from all involved. Nobody replied, and then I foolishly again sent another email while including you on, and this one was sent to Chris Ambrose. Now, Chris Ambrose is a litigant. Well, actually, first and foremost, he's a credibly accused child molester. Also, he's a litigant in the Connecticut Family Court, where he's gotten some very favorable rulings. And I believe, unless I am mistaken, his judge is Jane Grossman. Anyway, for whatever reason, he is put on the witness list. Now, Paul has written about his case, or someone on, and the blog is the Family Court Circus. At no point are any of the blogs regarding Chris Ambrose's case cited as some criminal, especially mean blog post. But for some reason, he's put on. So I wrote, Mr. Ambrose, it's Michael Volpe. I think you know me, but if not, here's my site. Why are you on the witness list for Paul Boyne's trial for writing mean blog posts against Connecticut judges? Were you upset when your friends in the judiciary were the subject of satire and ridicule? Is that what you will testify about? Do you understand that if you testify under oath, you have to tell the truth? It may come up that Mr. Bussert will ask you, Mr. Bussert is Paul's lawyer, if you have ever molested any of your adopted children. All of them say you did. Do you understand that your two choices are to plead the fifth, what I would choose, or answer honestly, admit to a crime? I'm looking forward to your next frivolous lawsuit. And say hi to Mr. Kasnoff for me. That's Alan Kasnoff. Chris likes to file a lot of frivolous lawsuits. Foolishly, again, I let Richard Luthman onto this email, and he had to chime in. Mike, Chris Ambrose' third choice is to perjure himself. That's not really a choice. He's done great at that in Connecticut, and then you've got a couple of articles about his alleged perjury. After all, word on the street is that Jack Doyle is everyone's, quote, hug buddy in New Haven, Who doesn't like a barbershop haircut? I wonder if Kasanoff taught him the quote dead duck song. And now you've got the dead duck strategy. Mr. Parlay is on number three above, and the Seahawks in the big game. That one is a lead lead pipe lock.
Lead pipe lock.
Wow, that
I'm
is
gonna parlay on
that
Christopher
is
Ambrose.
very mature. Now, before Paul went to jail, he told you something he learned in court on Friday about us. What did he say he learned? What did Jack Doyle is the New Haven County prosecutor, that's the equivalent of a DA. Though, as I've recently learned, they're not elected, but it's still basically the equivalent. But what did Jack Doyle pronounce in court?
Well, he said that I was mentally ill.
Well,
and then he said that you were a gadfly, basically. So he was trying to minimize our roles, and
but did he suggest that he was going to investigate us?
He did. He said he believed that we were involved in witness tampering by virtue of asking questions to his witnesses.
Folks, I'm not going to say that Google AI is infallible, but according to Google AI, witness tampering is a serious crime, but it occurs in the actions inducing or attempting to induce a witness to testify falsely, withhold testimony, skip court, or elude, that means evade, I believe, a legal summons. Now, I'm going to go back to both emails are pretty much the same. And I must tell you that I do not see any witness tampering per the definition that I found on Google AI. As you can see, in fact, I pronounce that you either tell the truth or plead the fifth if they ask you about criminal behavior. You suggested he has a third option, though you didn't encourage him to take
told him
the
he's
third
already
option.
done it.
Right. You suggested he probably would because he is known for doing it. I don't think any of the four emails, two by me, two by you, could be considered witness tampering. I think that was more of an intimidation tactic by Jack Doyle. What do you think?
He's trying to dismiss us as journalists, and people that properly should be covering the case, and that's only because Ed Mahoney is part of that Connecticut Judicial Journalism Board. So they actually they filter and give their state packaged points to Ed Mahoney. So the Current is like the state newspaper. So we are independent journalists, and actually Todd Booster did give us a compliment when he called us citizen journalists. I think we're a little more than citizen journalists, but he did respect that we were journalists. So
I don't care what Doyle calls us. That never bothered me. I've been quote journalist in quotation marks, wannabe journal. I don't care about that. If you want to insult me, that's not that big a deal. But I think I think what Doyle was doing was making a pronouncement in court, knowing that Paul would tell me or you or both of us. So I think through Paul, he was trying to intimidate us, saying, we're investigating you guys. You better knock it off. And folks, the Supreme Court has actually ruled that when the government engages in any kind of tactic that is meant to bully or coerce or threaten the media, in the Supreme Court's view, that's no different than passing a law. So when a county prosecutor suggests that media is being investigated, I think that violates the First Amendment as if someone had passed a law limiting free press. Am I wrong about that?
Yeah, it's applicable to the states with the 14th Amendment, the due process. But what the states usually do is they play the game like I see no evil, hear no evil. They play the game. I don't recognize Michael Volpe as a journalist. The same way, when they were trying to do stuff
they can
Yeah, it has to
say.
get to when it gets to a judge, it gets all thrown out, but it's not going to
Well,
stop them from doing the investigation.
there are. I think you identified like three characteristics of journalism: news gathering. What are the other two?
News gathering, organization, and dissemination. Those are the three
All
elements of
right.
journalism.
So I think it's fair to say that even though we were kind of immature, that this is part of the news gathering process right here. We have received a witness list, and we are asking questions of some of the witnesses. That is the news gathering process. And then, as a result of us doing the news gathering process, Mr. Doyle threatened us with witness tampering. So I would say that that is the equivalent of passing a law. Um, so
And you got to understand, Mike, we've been doing this a while, me and you as partners almost with journalism and with this. So you were going straight up with the question. You were like the good cop. And I was like the bad cop. I was going and trying to get a rise out of Chris Ambrose and getting a rise out of Judge Hess because you asked a
and
straightforward
I've
question.
I've
And
tried to get a right. I've tried to get a rise out of people, and I've done it before too. There's a guy named Paul Reitman who I got a rise out of him, and he sent me like 60 emails back. So there are different ways that you news gather, but what you saw that email, maybe you don't like the way we news gathered, but the free press means you can criticize us, but it doesn't mean we're not free press. But I find that what Doyle did in that courtroom to be no different than if the Connecticut legislature passed a law that you had to get a license with the state of Connecticut to be deemed a proper journalist. I think
well,
no different.
I'll put it in perspective. I find what Jack Doyle did in that courtroom no different than what Felix Dzerzhinsky did day in and day out as part of Lenin's Cheka. So
Right.
that's what this guy is in my book.
All right.
He's
So
a solitary and a hack.
the last update is that Todd Bussard, Paul's lawyer, filed a motion that I think is very accurate and speaks to the unethical behavior of the prosecutors. And he said, you have 68 right there, 68 names, positions on this witness list. This trial's going on for 6 days. You're not calling all of these people. You need to reduce the witness list because it's only done, you've only given us 68 people because then it's impossible for us to prepare. And there's something in the law, it's not like in the law books, but it's burying people in paperwork. And I've talked to lawyers and they've actually told me that's a lot harder to do. It's like during discovery, you give people so much that it's impossible for them to make any sense of it. But actually, most lawyers say they'll figure it out, and the more you give them, the better. But this is sort of the equivalent of that. We'll put 68 witnesses on the list. We're not going to call them all. We won't tell you which ones we're calling. And then there's no way for you to prepare because how are you going to prepare for 68 witnesses? Does he make a good argument here?
He does make a good argument because there are two separate devices in that the state conflated into one. When you do jury panels, right, and you're selecting, you do a voir dire, you can have a list of people that and things like entities, companies or law enforcement crew or anything like that you'll have on the list, and you'll read it out to the panel to see if they've heard of any of these names. All those names don't necessarily have to be witnesses you intend to call a trial, but they may be people that are relevant to the case that you'll hear about during the case, or places or things or like that. So you don't want, like, let's say you have Danny's Corner Barbershop is the place where that the trial is going to be about. You would put the name Danny's Corner Barbershop. Does anybody know Danny's Corner Barbershop? And you'd ask, because if you go there every day, you would form your own opinions about it based on your experience, and that might not be something that either the prosecutor or the defense wants you to have. So that's the list that they'll read out to the jury panels to hear, so they'd have to bring up those names. That's separate and distinct legally from the witness list. The witness list is the tight list of witnesses that are going to be called or may be called for trial preparation for due process. Okay, so because the defense has to have the ability to prepare for all of the witnesses that are going to be coming and make use of any of the materials about the witnesses. By having 68 witnesses on something that's going to be a 6-day trial makes it impossible, nearly impossible to properly and adequately prepare for everybody. And
And
some
you
of these
don't,
witnesses are just crazy people. They're just crazy
right,
people.
you don't, and then of course you have to prepare for all of them, even, like Chris Ambrose, I doubt they're calling him. This, I think, is the key paragraph. Supplying nearly 70 names to defense counsel has the effect, whether intended or not, of obscuring who the state actually intends to call a trial. This undermines the notice and disclosure provisions of the Plastics book and interferes with defense counsel's ability to efficiently and effectively prepare to confront the witnesses who will actually be called at trial. He says, I don't know if that's what you meant. Of course, that's what Doyle meant to do. He threw out nearly 70 names, so there's no way for you to prepare properly. This is reprehensible, in my opinion, and really borders on misconduct, the
Well,
kind of
actually,
misconduct that somebody should take action against. Not that anyone will.
what Todd's doing is asking them to pare it down. However, what he
Mm-hmm.
did, Jack Doyle, was he made a fatal flaw here, and this
Mm-hmm.
is a concept in the law that we hear. It's called opening the door. When you
Mm-hmm.
open the door to something, the door stays open for all purposes. So for all 68 of those people, Jack Doyle has opened the door, and if Paul wanted to, Paul could call any of those 68 people as his witness. So by
Mm-hmm.
putting Joette Katz on that list or any of the other judges, I think there's 7 or 8 judges, Paul could
Mm-hmm.
call every one of those people, and it would be very hard for the judge to say no without it being reversible error because the prosecution has opened the door to these people by placing them on the witness list.
Mm-hmm.
So that's the risk that he ran by putting everybody on there. And I think maybe Paul's in prison right now or in jail right now because of that. I think they're afraid that
So
if
every
Paul
one
goes to
of these
trial,
folks can now be called by Paul. And then
yeah,
you mentioned I think it's a U.S. Supreme Court case, Giglio. Now he can
Giglio,
get back.
Giglio
Explain
materials.
how that works.
So Giglio materials are stuff that you get about police officers that are on the case. And there's a whole bunch of police officers. You'll get their
There's a
conduct,
few.
any past misconduct that they have. You'll get their personnel file basically, if to the extent that it's relevant to the case. But the whole Giglio concept, especially the Connecticut law, you could make an evidentiary showing that you need the same type of Giglio type materials for all the people on the witness list that are state actors. And so the judges are clearly state actors. So you should be able to get all of their all the judicial complaints against them, anything in their judicial record, a lot of that stuff, because that stuff may very well be relevant to what's going on. So by way of example, let's say Mukhauser, who's
Mhm.
one of the victim witness judges, Thomas Mukhauser. Let's say
Right.
he had,
Right there.
a whole bunch of judicial complaints against him, and
Mhm.
that kind of jaded him in a certain way. Paul has a right to know about that and to say that the complaint that was made by Mukhauser was because he's jaded because he's been complained about for X, Y, and Z by these people. So he should get at least all of the judicial file on at least the 3 witness judges and probably more. Joey Katz probably too because of her involvement. He can make a prima facie showing, I
And
think.
now Paul can call William Tong.
Yeah,
No,
he's
he's
there.
not just in the Connecticut office of the Attorney General. This is the elected Attorney General for the state of Connecticut. They didn't get back to me. So we don't know, but Paul could call him and Todd Busser could say, why do you think Mr. Doyle put you on the witness list? And
Yeah.
I, I think that question, you'd have to frame it right. That probably is a question that could be objected to, um, because you're asking him to,
You're asking from the state of mind of somebody else. Yeah, that'll
right?
be.
Yeah, but there is probably a question that could be, or I guess you could ask, do you have any relationship to this case?
Mr.
Have you
Tom,
ever
Tom, do you know why you're here today? That's the
Right.
best question.
Did you ever investigate Paul Boyne? There's a lot of questions that could be asked of William Tong. So I
And
guess,
there's
open the door. What Bussard wants is a realistic list, not 68. And I don't know if that's been ruled on. So this judge, and here's one other interesting thing. We should have put this on. This hearing was called last minute on Friday.
Friday
And
afternoon.
Paul doesn't live in Connecticut. He had to get out here or out there. That's number one. Number two, in the interim, in between Friday and Monday, Jack Doyle, he withdrew the motion to increase his bail. Now, if Jack Doyle withdrew the motion, how did the bail still get increased?
I think that the court did it sua sponte is what
All right,
I
now
don't have the
sua
full.
sponte, that's legal talk. I am not Harmeet Dilan. I did not major in Latin in college. You heard about that controversy.
Yeah.
She got all bent out of shape because she majored in Latin. I did not major in Latin in college. What does sua sponte mean?
That means on their own, by themselves.
Right.
So the judge on its own motion or its own can do
Right.
something.
No one asked him.
I'm not sure if that happened because I didn't get all the documents, and there were court watchers there that I spoke to, and people in the courtroom, but we're not privy to whether or not that motion.
If
But what I
Doyle
heard,
withdrew it, that means he did it on his own. That's very extraordinary. This case. They are not only are they corrupt, but they're brazen about it. They know that people are watching, and they keep doing it. And they picked the jury. Last thing, they picked the jury. Why? Why is there no trial? The way I'm familiar with it, you pick a jury, you start. How come they didn't start?
in a way, even in Connecticut, a lot of places they go pick and stick. So they picked the jury, and they said, "Okay, we'll call you in a couple of weeks when we're ready for you." Or we might not call you at all. So it could be a month before they come. It could be 2 months before they come back. But they're waiting, and every month, every week they got to call back and see if Monday they got to appear. So that's
all right. So we'll see. So far, they've picked the jury. They haven't started the trial. There are still a variety of issues that they have to resolve. Paul may be in jail 6 weeks, 8 weeks, possibly more. So we will keep you updated.
One more thing, Mike. The other thing is this: Paul they ordered it today, cannot possess any of the paperwork from his case. And so that's raising huge due process issues because you need to be able to have an effective assistance of counsel. And part of effectively assisting your counsel is being able to look at the documents and tell your counsel what's going on. Right. And so he's like, they think that he's a terrorist with these documents, that they're state secrets and something like that, treating like that. But we had this conversation, Paul and I, about what would happen if he got thrown back in and they did this exact thing to him. And one of the ways that he might go is he might actually be firing Todd Bussard almost immediately, because that places him in a situation where he can represent himself under Ferretta versus California. And if that's the case and he's his own lawyer, then if they don't give him access to his documents, then they can't have a trial. It's a mistrial at that point. So they would have to do it. Plus, if he's in jail, and I know somebody that's been there, you get more leeway if you're your own lawyer. You get to go to the law library and you get to work on your computer for 8 hours, 10 hours a day, as much time as you want in preparation for your trial, rather than sit inside the cell or sit inside a common area all day. And I think it might be better for Paul, actually, at this point, to get rid of his lawyers. I think that if he had that, then that's something he'd be better off.
Paul knows now. Is he going to be able to file things properly and object and do?
They created this problem, so the court has to make accommodations. They created the problem. They decided to put him into jail, and that was in the balance.
No, but I mean, if he's representing himself and Jack Doyle asks a leading question, is he gonna be like, is he gonna know enough to say objection leading, objection relevance?
Todd is a good trial lawyer, and that's some of the things that a trial lawyer knows. But the thing about Paul's case is this: they've given him nothing left to lose at this point, and he's in jail, so it's nothing left to lose. He might as well go in and take the stand, because I don't think most defense attorneys would want their client to take the stand. He go and take the stand, tell the jury what happened to him, tell the jury what's happening to him, and I think that he might have an effective, unorthodox strategy, being Paul. Paul might just come in and he might be able to pull a rabbit out of the hat, because this is so far off the grid of what you would expect at a trial. If he were to get rid of his attorney and make his own presentation, in the Paul way, okay, because Paul does communications. He's a communicator like you and I. So he might be able to communicate in a way that's so unorthodox that he might actually be able to pull a rabbit out of a hat. And that starts with getting rid of the lawyer, getting all of his materials, working on them himself, and coming up with his own strategy. And that's what I would do if I were. They're going to put him in jail, make that into your source of strength. Because as a matter of course, if he represents himself and he's not allowed to have his papers and he's not allowed to prepare while he's inside jail, then there's a due process violation off the bat. So it puts the onus back on the other side. He should turn jail not into a point of weakness, which it is now. He should turn it into a point of strength, and all that only happens by getting rid of the lawyer.
All right, I think it's a due process violation already by not giving him documents. And
It is.
these guys are so afraid of allowing these documents to get out, and it's because it makes a lot of people besides Paul Boyne be not look because a lot of people besides Paul Boyne are guilty, and these documents are evidence of their guilt, and that's what they're really afraid of. Like all of these witnesses, most of them you knew. I mean, you didn't know that the state police and the judges who claim their victims are going to testify against them. Give me a break. And this thing, I think they were looking. Brown was looking for a reason to put Paul back in, and now he found one. Now he's back in. But we're not done with this, and I think this will create the Streisand effect, and it will create more scrutiny of the trial, which is what they're trying to avoid. All right, we'll be back next time.